Hello and welcome back. I'm attorney Andrew Bethel of Bethel Law, here to scare you once again into talking with an estate planning attorney. Today's topic is a juicy one, the right of illegitimate and omitted children in California when it comes to wills and trusts. This subject came up after a comment on one of my recent videos, and it's clear that there's a lot of anxiety, confusion, and perhaps a little embarrassment too about this area of law. So hit like, subscribe, share the video with that family member you know has that long-lost child, and let's get started. First, let's define what constitutes an illegitimate child under California law. Historically, children born out of wedlock were often denied inheritance rights. However, times have changed, and California law now ensures that all children, regardless of their parents' marital status, have equal inheritance rights. This means that under the law, we no longer care whether the child in question is legitimate, illegitimate, planned, or unplanned. If that child is a blood relative to you, then they are a natural heir and thus are entitled to a share of your estate. But don't just take my word for it. Let's read some actual code sections. California's Probate Code Sections 6450 to 6455 specifically address the parent and child relationship for inheritance purposes. Probate Code Section 6450 states the relationship of a parent and child exists between a person and the person's natural parents, regardless of the marital status of the natural parents. This means that illegitimate children have the same right to inherit from their parents as legitimate children. Furthermore, Probate Code Section 6453 establishes that a natural parent and child relationship is presumed under the Uniform Parentage Act. This can be established through various means, including court orders or clear and convincing evidence that a parent has openly held the child out as their own. Why, yes, that does open the door to non-blood related individuals to be considered as your child under the law. We'll come back to that. Let's stay on topic for blood relatives for a moment. Let's step over into trusts. Trusts are legal instruments used to manage and distribute a person's assets outside of a probate court. The terms of the trust document usually govern who inherits the assets. However, there are scenarios where illegitimate children are not named in a trust. Oftentimes, it might be a little embarrassing. I have seen instances where kids find out through mom and dad's trust that they had some long-lost half-sibling out there that they were never told about. And no, it wasn't only from dad. I've seen cases where mom also didn't mention another child floating around out there, and the kids only find out through the trust after mom's passing. In cases like these, the specific language in the trust document is crucial. I have seen it said that if an illegitimate child is not mentioned, they generally don't have a claim unless the decedent's intent can be proven otherwise. But that's not the case. If there is a child out there that was not specifically acknowledged in one's will or trust, then they could make a claim on the estate for what their inheritance share would have been had there been no documents. So, if there were one of two children, then 50%. If there were one of three, then 33%. If one of four, then 25%, and so on. That means if you try to bury your head in the sand and not tell your attorney that there is another child out there, then you're running the risk of them coming in and making a claim for a part of your estate. If you don't want them to have anything, we must still acknowledge their existence and clearly state that it is your intent for them not to be considered a beneficiary of your estate. Let's look back at the California Probate Code, specifically Section 21620, which states, if a decedent fails to provide in a testamentary instrument, meaning a will or trust, for a child of the decedent born or adopted after the execution of all the decedent's testamentary instruments, the omitted child shall receive a share in the decedent's estate equal in value to that which the child would have received if the decedent had died without having executed any testamentary instruments. There are, of course, exceptions to this. Section 21621 lays out the exceptions. First is where the failure to provide for said child in the will or trust was intentional, and that intention appears from the testamentary instruments. Fairly straightforward, but in that case, you're likely acknowledging their existence in the first place, and thus your intent shouldn't even be in question. Next is where you have one or more children, but name the other parent of the omitted child as the beneficiary of substantially all the estate. In essence, you provide for the omitted child, but in a more indirect way. And the last exception is where you still provide for that omitted child, but you do so outside your will or trust and do so with the intent for that transfer to be in lieu of a distribution from your will or trust, so long as such can be shown by a statement from you or from the amount of the transfer or other evidence. For example, let's say you provide for your children of this marriage in your trust, but you fail to mention that you had a child from your first marriage. However, you leave a bank account of $100,000 to that first child as a pay-on-death beneficiary. Of course, there will also need to be some evidence that you intended for this to be their inheritance rather than receiving something from the trust. And to close the book on this section, the provisions for omitted children apply in cases where the person creating the will or trust either believed the child in question to be dead or where they are completely unaware of the existence of the child in the first place. And lastly, where does the omitted child's share come from? Well, any portion of the estate not addressed in the will or trust, or, more likely, from the share of the other named beneficiary, proportional to their share, of course. So, can illegitimate children make claims if they're not named in a will or trust? Well, as we just discussed, yeah, and easily so. In trust and probate proceedings, all potential heirs must be notified, including illegitimate children. It's all going to come out in the wash. There are companies out there whose whole business model revolves around finding heirs and connecting them with ongoing probate cases in exchange for a percentage of their inheritance. It's best not to leave your family with any unpleasant surprises. Let's quickly look at a real-life example. In the case of the estate of Nick Martino, discussed in one of my previous videos, Martino's stepchild was able to claim an inheritance right due to the strong familial relationship and despite no biological connection. This case is an excellent example of how the courts can interpret family relations, and even though the stepson claiming a portion of Martino's estate was a stepchild rather than an omitted child, legitimate or otherwise, the principles that determine what that stepson's inheritance share was are found in what we're talking about today. The stepson was able to establish a familial relationship sufficient for the court to consider him an heir of Martino's estate, and once that was established, the probate code kicked in to say that his share was going to be 1/3 of the estate in that case. So here's some practical advice. If you are creating a will or trust, be very clear about your intentions. Specify all your children, not just those of the current marriage or the ones you like, and do so by name. On the flip side, for illegitimate children, if you believe you have a claim, you should seek legal counsel to understand your rights and any potential claims you might have. To summarize, California law does not discriminate between legitimate and illegitimate children regarding inheritance rights. If you leave a child out of your will or trust, either intentionally or unintentionally, the probate code will provide for that child from your estate, regardless of whether that child is legitimate or not. Thank you very much for watching. Don't forget to like, subscribe, and share the video with your family members. I'm attorney Andrew Bethel, and I'll see you at our next meeting.